We are watching The Truth Be Told on Boom Live. I'm Faye D'Souza. Thank you for joining us. We're having conversations around COVID, the impact of the virus on our lives, on our businesses, and what we should be doing as each of us as individuals to mitigate those risks. Today, we're going to ask a question that's particularly relevant to entrepreneurs and business owners. Now, effectively, none of us have gone to work for over a month now. Our offices have been closed, but the rent continues to pile up. What are the legal recourses or the legal options available for business owners and entrepreneurs if you can't pay your rent or if you can't make payments at this point? Remember, while in India we have something called a standard contract of lease, and the standard contract invariably doesn't include a clause of act of God or of clauses of unforeseen circumstances. So in this case, in a case like this of a global pandemic, which none of us could have really foreseen, what are the legal options available to us? Now, to help me answer these questions right now, I have Mr. Amit Khemka, who joins us. He's a very respected lawyer in the Delhi High Court, and he also specifically is an expert at economic offences and laws that govern businesses. Mr. Khemka, good evening, and thank you for joining me on this conversation. Tough option right now for business owners and for entrepreneurs. Is there any room within our contracts, in your opinion, for not being able to pay rent at this point?
Yeah. So, Faye, let us have some background, to understand what this law is all about. Till almost the end of the 19th century, we are governed by common law. All the laws have emanated from common law. Even our legislative laws have emanated from common law. So till the end of the 19th century, a lot of sanctity was given to what is written in the contract. Whatever is the contract, come what may, one is bound by it. One cannot wriggle out. Whatever he has agreed to, he must stick. But for the first time, in a case of Taylor versus Goldwell, the court came out with a concept that where the whole basis of the contract is struck because of an act, like you call it act of God, which is something which is beyond the powers or beyond the control of a particular person. So this concept of force majeure has been, or doctrine of frustration of contract has been, it came into the law. Thereafter, there have been thousands and thousands of judgments over it. Then our own Supreme Court, our own legislature has incorporated two clauses. One is in the Transfer of Property Act, that is Section 108BE, and other is Section 56 of the contract, which recognizes the force majeure. And it says that if there is a contract, you will be governed by the contract. If there is a contract in which the force majeure clause is there, then there are judgments of Satyavrata and others which say that you will be governed by that particular clause only, whatever that clause says. But if there is no clause, then in that case, Section 56 of Contract Act and Section 108 of Transfer of Property Act will come into picture. Now, Section 56 of the Contract Act will only deal with cases which do not involve leases of the property, while 108 will deal with the lease issue. So, both these, we have to differentiate. I mean, all other contracts, for example, a person is not able to supply goods because of the lockdown. Now, in that particular case, he can say that, okay, or he cannot complete a project. So he can say that, okay, because of the lockdown, I am not able to do it. Therefore, I am not bound by it. Therefore, frustration of contract comes into, therefore, the contract becomes void. While under 56, a contract becomes void because of force majeure. because of frustration of contract. But that does not happen in the case of Section 108. The lease does not become void just because a force measure is there, just because an unforeseen act of God is there. In that case, the tenant has to make an option to avoid the lease, to declare it void. He has to give a notice to the landlord. Now, the tenant cannot, there used to be a concept of abatement of rent, but there is no question of abatement of rent now. What can be done is the tenant can choose to terminate the contract. He can say that, okay, because of the force measure, I don't want to be now, it has become impossible to do the work, it has become impossible to use the property, therefore I want to get out of it. Now, why it is that so? I'll just explain in one more sentence. Say, for example, residential contract. I'm living in a house. I am living in the house. So how can I say that I'm not going to pay the rent? But in commercial contracts, for example, you have a shop in a mall, then the government's order says that no shop in the mall will be operational. There you can say that this property has become unusable. I am not able to use this property, and therefore I want to terminate that clause. But you can't remain in possession of the property and say that I will not pay the rent.
Mr. Khemka, yes. Mr. Khemka, what happens on failure to pay the rent? Let's assume I have a shop. I have not done any business in that shop right now, but I'm effectively still occupying it because my material is there, my all of my things are still in the shop. I have not been able to pay the rent. Can the landlord then proceed against me after just this 1 month? Is there legal room for prosecution here?
Not prosecution, but the landlord can recover the rent by way of civil proceedings. He can tomorrow go to the court and recover that rent from me. I cannot seek, the tenant cannot seek a rent holiday or abatement of rent as we say in law. The abatement is not allowed under the law. Only option with the tenant is that he can surrender the possession, he can terminate the lease. He can say that the lease has become void, so I'm giving you the possession. He can offer the possession back. That is what probably he can do. Otherwise, he cannot remain in possession. He cannot say that, okay, I will use it. There is a recent judgment of Sangeeta Patra, which has been even upheld by the Supreme Court, where the court has very categorically said that if you remain in possession, if you don't declare the lease to be void, then in that case, the tenant is liable to pay the rent.
So, Ms. Khemka, so you did say, of course, that there is no room for abatement of or a holiday under our law, which is that I can't ask the landlord, okay, give me 1 month's grace or 2 months' grace where I'm not able to pay and then start collecting after 3 months. Why is that?
Basically, if you see the whole law of force measure is based on equity. It is based on fair play. That if a person is not able to use something, he should not be saddled with the rent. But look at it from the angle of the landlord. He has a property. You are remaining in possession. You are continuing to be in the possession of his property, but you don't want to pay the rent. So the law has given the tenant an option that he can surrender the tenancy. He can get out of the tenancy, he can declare the tenancy to be void, and then say, okay, now I am not liable to pay the rent. So you can't be in somebody's property, you can't remain in possession in the hope that in future you will be able to use that property and not pay him in the interim. So that is why this whole balance has been drawn. In fact, in one of the cases of Raja Dhruv Dev, the Supreme Court way back in 1968 said that where the lease of agricultural land was granted and the riots broke out. And because of the riots, because of the post-partition riots, the that atmosphere in that area became such that it became difficult to do the agriculture in that particular place. The court did not grant a rent holiday. They said that okay, you could have gone ahead and declared the contract void. You know, in Sangeeta Patra's case, which I am telling you of Delhi High Court, there the property became unusable because the property had got demolished. It had fallen, its roof had fallen. But the court said that you had the choice to say that okay, the contract has become the very foundation of the contract has gone, and therefore I am entitled to void the contract, and I am just terminating the contract. I am terminating the lease, and thereafter you will not be liable to pay the rent. But here in this COVID situation, it's a very difficult situation. The Delhi High Court, in a very recent judgment where the question was of bank guarantee in respect of certain project, the court has said that COVID-19 situation is prima facie a force majeure situation. The court has said that. But that does not entitle on its own the tenant to remain in possession of the property and not pay that.
Okay. So in your legal opinion, Mr. Khemka, finally, you believe that as tenants, if you aren't able to pay rent, then your only choice is to surrender the property, vacate it, and give it back to the landlord, vacate it completely. But there's no option here to say, I can't pay for 2 or 3 months. Please wait that long, unless the landlord, from the kindness of his or her heart, decides that, listen, I'm not going to collect from you. That's a possibility.
Yes. Yes.
Okay.
And you know, some of my clients who sought my opinion on it, and they said that should we write that force majeure situation has arisen and therefore we are not liable to pay the rent and all. I said, please invoke the goodness of your landlord. Don't threaten him with law. Okay, so the best way to, the letters our clients have written that look orders of the court, we are paying to our employees, we are fulfilling all those obligations. So please help us right now. At least if you can't give us the rent holiday, at least defer the payment of rent for a situation when the things become good again. So that is how our clients have written letters to their landlords. They have not threatened them with the law because they can't vacate the premises. After all, the huge amount of infrastructure has been created in those properties. So they have invoked the goodness of their landlord. They have not tried to threaten the landlord with anything.
All right, Mr. Khemka, this is really, really helpful. And I'm sure there are thousands of lakhs of people across the country who would find this information helpful right now as business owners and entrepreneurs who are trying to figure out. Yes, please go ahead.
Yeah. One more thing. The government has said that in case of poor people, the landlords must not charge the rent. Now that order stands, but we people have our reservations that whether under the Disaster Management Act, the government has any such powers to give such orders, because it will ultimately, I feel that its legality will not be could be challenged, because under the Disaster Management Act, the government has powers which are emergent in nature. They are not as if the government will give away all our rights, everything, and whatever the government says will be the last word. So these orders can also be challenged tomorrow. And I will only say that be at good relationship with your landlord. Don't threaten him with anything. So invoke the goodness of your landlord.
So to remind you to always send your landlord a box of Diwali sweets when this entire time, to build that relationship, because that's effectively what you're going to be falling back on at this point. The law has no room here for a rent holiday. It only has room for the kindness of the landlord's heart. Mr. Khemka, thank you so much. And I hope we can continue to have these conversations, as obviously more and more of this is going to keep coming up in the days and the months to come. Amit Khemka, thank you for speaking to us on Truth Be Told. Remember, if you have questions, leave it for us at the bottom of this video. And also, for all of your fact-checking needs, go to Boom Live. Thanks for watching.
Thank you.